This is a case that's been bounced around back and forth throughout the court system.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
Justice's ruling this morning, it conflicts with the Second Amendment's right to bear arms.
Supreme Court just rewrote the rules. The Supreme Court just detonated a legal bombshell, and the aftershocks are already shaking gun control laws nationwide. In a unanimous 9-0 ruling, the justices have redrawn the lines of the Second Amendment, and what just happened could permanently shift how America treats lawful firearm ownership. For years, anti-gun lawmakers believed they had momentum, crafting restrictions and building legal shields around enforcement agencies. But that momentum may have just collapsed in seconds. This is not speculation, not political theater. It is a real decision with real consequences, and it marks the beginning of a fight that could decide the future of gun rights in all 50 states. Subscribe now to Survival Firearms, because if you carry, train, or believe in your rights, you deserve the truth before the headlines bury it. Hit like, share this with your community, and stay sharp. This is the moment history turns. Chapter 1. Supreme Court Turning Point. The Supreme Court has accepted an emergency case that challenges permit requirements for firearms in all 50 states. This move puts the current permit system on the chopping block and signals a possible nationwide shift. The fact that the case was granted under emergency status shows how urgent and consequential this decision might be. Gun owners across America could wake up to a completely different legal landscape very soon. The court will review whether states can require permits simply to own or carry firearms. The emergency status means the decision timetable will be much faster than usual. No prior case has directly confronted every state's permit laws at once. If the court rules broadly, permit requirements could vanish overnight nationwide. If this ruling goes the way many expect, we could witness the end of government permission slips for Second Amendment rights, a change that will ripple across every state and alter the debate over gun ownership forever. Chapter 2. Freedom states lead the way. In 27 states, people already carry firearms without needing permits, meaning many Americans are already accustomed to exercising gun rights freely without bureaucratic hurdles. For residents of those states, the court ruling may feel like confirmation rather than revolution. Their everyday reality may remain unchanged. But the contrast with permit states will become sharper than ever. This ruling will bring renewed attention to constitutional carry as a viable model for nationwide adoption. Constitutional carry states allow firearm ownership and carry without permits. Residents in those states face minimal government interference. These citizens already enjoy freedom to exercise their rights without delays or fees. A favorable ruling will enshrine their system under the Constitution rather than state law. For many Americans living under constitutional carry systems, this decision will not just preserve their freedom, but strengthen it by removing any lingering legal uncertainty. It marks a potential turning point in how America views gun ownership at a national level. Chapter 3. Permit States. On edge. For citizens in the 23 states that still enforce permit requirements, the coming days could bring confusion and uncertainty. Laws that once seemed stable may unravel or be challenged. State governments may scramble to respond, and ordinary gun owners may find themselves caught in the crossfire. Permit systems currently impose fees between $150 and $800 in many states. Applicants often wait weeks or months just to get approval. Licensing authorities have wide discretion to deny permits with little justification. The difference between legal ownership and a felony could depend on which side of a state border you cross. This legal limbo threatens to undermine the principle of equal rights under the Constitution. Gun owners in permit states need to brace for significant upheaval, not just in laws but in daily life as regulations shift and new uncertainty sets in. Chapter 4. Why permits are under fire. The argument brought before the court challenges permit requirements as a fundamental contradiction to constitutional rights. The reasoning is simple. When a government demands permission slips or fees before you exercise a right, that right becomes conditional, not inherent. This logic applies equally to speech, religion, privacy, or gun ownership. The case could force courts to rethink whether any constitutional right can be subject to bureaucratic approval. Plaintiffs argue that the government cannot require approval to exercise a constitutional right. They claim the Second Amendment should be treated like First Amendment rights, such as speech or religion. They contend that fees and bureaucratic delays are modern barriers to rights. They maintain that permit systems are rooted in public safety policy, not in the original constitutional text. If the court accepts this reasoning, we may see a sweeping shift in constitutional law, where any law that makes rights contingent on government permission becomes unconstitutional. The ruling could dismantle decades of gun control laws built around permit regimes. Chapter 5. The truth behind permit laws. During the court hearings, historical evidence surfaced showing that permit systems were not part of the founding era law. Americans in the early republic freely carried firearms without government gatekeepers. Permit laws only began appearing in the early 1900s, often in states with histories of racial or immigrant discrimination. That context undermines the ethical and constitutional legitimacy of permit requirements as we know them. Historical records show no founding-era laws requiring either gun ownership or carry permits. Early American citizens carried firearms as a natural right without government permission. Permit systems emerged only in the 20th century. Many of those systems were originally designed to disarm marginalized communities more than to protect public safety. This historical context casts permit laws not as neutral regulations, but as discriminatory measures repackaged over time. By exposing that origin, the challenge before the court gains moral as well as constitutional weight, which could sway the outcome decisively. Chapter 6. States preparing new barriers. If permit regimes end, many states are already preparing radical overhauls under the guise of compliance. Some may quietly rewrite regulations to sidestep the ruling, and others may replace permits with new barriers like mandatory certifications or insurance obligations. This fight will not just be about legal status, but about maintaining control over who can realistically access firearms across the nation. Anti-gun states are reportedly drafting backup legislation ahead of the Supreme Court ruling. Proposals include mandatory firearm safety certifications before ownership. Other ideas involve requiring liability insurance policies similar to auto insurance. Some bills may demand background checks for every ammunition purchase or state-controlled training courses with limited availability. These alternative schemes may avoid the word permit, but achieve the same effect by restricting access through financial obstacles, bureaucratic delays, and private gatekeepers. The battle over gun rights will move from courts to legislatures, insurance offices, ammo counters, and training classrooms as state governments test new ways to control access. Chapter 7. Backdoor Gun Control. In states like New York, California, New Jersey, Massachusetts, and others, the fallback plans are reportedly ambitious from a regulatory perspective, but deeply concerning from a rights perspective. The aim is to keep gun control alive even if legal permits are struck down. The fight is shifting away from permit paperwork to certifications, training mandates, insurance requirements, and ammo purchase restrictions, which could effectively reinstate control through different mechanisms. Alternative schemes may require mandatory firearm safety certifications. States may demand state-approved liability insurance before one can legally carry. Background checks could be required before every ammunition purchase, even if gun ownership is legal. States may control which instructors are approved for mandatory training courses, with limited slots creating long waiting lists. These measures may not call themselves permits, but the impact would be the same: ongoing restrictions on access, bureaucratic control, and inequality in who can exercise gun ownership rights. Citizens must understand that the end of permits does not guarantee real freedom unless they remain vigilant to these backdoor schemes. Chapter 8. Rights for the rich only. Permit systems and potential replacement measures disproportionately harm vulnerable Americans often living paycheck to paycheck. For them, firearm ownership can be the difference between life and death rather than a hobby. High fees required training and insurance, and strict background or ammo purchase rules exclude those with limited means. What emerges is a system where rights exist only on paper for many, but in reality remain out of reach. High permit fees and the cost of mandatory training price out low-income families. Long waiting periods and bureaucratic delays leave people defenseless in dangerous times. Insurance-based requirements may lead to no coverage being offered or prohibitively expensive premiums for residents of certain states. State control of instructor approval may allow ideological gatekeeping or arbitrary denials. The result may be that constitutional rights are reserved for the wealthy, the politically connected, or those willing to wait and navigate obstacles while millions remain excluded from meaningful access. This systemic inequality undermines what constitutional rights are supposed to protect. Chapter 9. What happens after the ruling? If the court strikes down permit requirements, the ripple effects will be immediate and dramatic across America. States that embrace constitutional carry will set the tone, while others may resist or attempt to rework laws behind the scenes. Federal lawsuits may become necessary to force actual compliance. The future will depend not just on judges, but on activists, legislators, and everyday citizens staying alert. States where constitutional carry is already law may seek confirmed rights without delay. Permit states may attempt to enact workarounds quickly before enforcement begins. New legislation may attempt to rebrand restrictions as safety certifications or insurance mandates. Civil rights groups and gun owners may need to file new lawsuits to challenge disguised restrictions. What happens over the next few weeks and months? It may define gun rights for decades to come. If pro-rights Americans remain silent or passive, the threat of backdoor restrictions remains real, but informed and unified action could hold those changes off or reverse them permanently. Chapter 10. Your role in this turning point. This is not the time for complacency or assumption. Even if the court seems poised to deliver a victory, real freedom depends on public vigilance and active engagement. Know your state's current firearm laws, monitor proposed legislation, and reach out to lawmakers. If you care about protecting your rights, get involved with gun rights and civil liberties organizations, and keep pressure high to ensure any legal changes remain fair and constitutional. Your voice matters now more than ever. Research and document your state's existing firearm laws today. Subscribe to local and national gun rights organizations for legal updates. Contact your state legislators to express support for constitutional carry and opposition to backdoor restrictions. Share accurate information with family, friends, and your community to spread awareness and understanding. Your engagement and advocacy could influence the future of Second Amendment rights nationwide. Stay informed and active to help shape outcomes rather than just react when changes come. A new era of the Second Amendment. The fight for freedom is not slowing down, but gaining momentum with every legal challenge and every citizen standing up for their rights. Major rulings like this show exactly why vigilance, knowledge, and unity matter now more than ever. Gun owners across the nation must stay alert, informed, and ready to defend constitutional freedoms. Your rights matter more than ever, and together, we can ensure they remain protected.